Okay, today I'm going to talk about introduction of director. Okay, under Section 2, Companies Act 2016 includes director as any person occupying the position of director of a corporation by whatever name called and includes a person in accordance with whose director and instructions the majority of director of a corporation are accustomed to act and the alternate or substitute director. Director can be defined as an appointed or elected member of the board of directors of the company who, with other company, has the responsibility for determining and implementing the company's policy. Director is an officer in the company as stipulated in Company Act 2016, which includes any director as an officer of the company. Other than that, a company director does not have to be a stockholder, which means shareholder or employee of the firm, and may hold the office of director only. Director act on the basis of resolutions made at director meetings and derive their power from the corporate legislations and from the company's article of association. The director being appointed by members during members' meeting and is responsible to carry out day-to-day administrations and running a business operations. They are the one persons who set the strategic goals of the company and ensure the smooth operation of the company. It is very important to board of directors to ensure that they are maximize the shareholder. Minimum number of directors in public company at least 2 directors, and minimum number of director of private company is 1 director. In this report, we only discuss for the type of director which is executive and non-executive and fiduciary duties of director.
Hi, Assalamualaikum. My name is Nurul Ain Afira binti Mazrizam. I'm going to talk about the first question of the chapter 5, director. So the question is about the issue whether Zhu Jiang and Lai Qi can be appointed as a director of XLRB Berhad. Director means any person that is responsible for the management of the company. For example, Chief Executive Officer, Chief Financial Officer, and a Chief Operating Officer. So Zhu Jiang and Lai Qi appointed as a director in way of appointment in corporations. Open in corporations, it is to establish a public company limited by shares. In Section 202 Companies Act 2016 stated that the person that is named as director in the application for incorporating a company should hold office as a director. I'm going to talk next is about the qualification to be a director, which is in Section 196, Subsection 1 of Companies Act 2016 that said that it is required names at least 2 directors for incorporation of a company, and these names are generally given by the person who incorporates the company and these directors. So it is like when their names in the company at first, they will automatically be one of the director, like because they together like establish the company. So at the first annual general meeting, it is a legal obligation that the first director be named in the company's memorandum or article of association in Section 122, Subsection 3 of Companies Act 2016. A director should be at least 18 years old who has its own statutory personality, which stated under Section 196, Subsection 2, Companies Act 2016. So, also the director should typically residing in Malaysia by having a crucial place of residence in Malaysia. So, in fact, they can be one of the director because they have like the first place because they established the company. In the case for Fong Po Yuk versus and the Central Construction Co. Sdn Bhd define means of what resident mean. In the case, resident means tenancy in a place with a stage of continuity that should not include an alternate or substitute director. So, it means that they could fulfill the minimum number of director for company limited by shares. So, the disqualifications of director that's stated under section 198, which is the circumstances of disqualification of director, occur whether the offices happen inside or outside Malaysia, because Leci has bankrupt like outside Malaysia, but it still like need to be thought about because she is one of the directors, so it may she may not qualify for a director positions. So this question is: a person should not hold office as a director of a company or directly or indirectly be concerned that the lead contributions and of the management. Okay, next one is if the person is an undischarged bankrupt, which is general is disqualified from holding certain public or private offices. So, if a person has convicted of an offense related to the promotion, formation, or management of a corporation. So, in terms of financial management, director has been appointed in order to manage the company. So, if the director fails to do it properly, she may convict with an offense under the company's law. So, the director should avoid taking bribe to keep the company's pride like in its own situation, like not to be like non-active company. So Leci because she is bankrupt, so she cannot be one of the director for temporary times because she legally prohibited from managing, forming, or promoting a limited company, so she cannot be one of the director. If she attempts to become a company director while her bankruptcy is undischarged, she will break the law. So, once her bankruptcy has been discharged, she can be a director again. So, there's a burden control over the asset. As an undischarged bankruptcy, it's really hard to secure credits for many years. That's why we cannot choose an undischarged bankrupt person to be one of the director, because it may not help the company, probably make it worse. So most importantly, the ability to control business will be decreased eventually. So it is really to whatever I think that most that really relate to these qualifications of director. So we need to be more systematic to choose the director in order to make it the company more effectively.
As stated under Section 202 subsection 2 and Section 208 subsection 4, subsection A subsection B of Companies Act 2016, the appointment of director also can be appointed by Board of Directors. Subject to the Constitution, the board may at any time appoint in addition to existing director. They can decide it in the board meeting. The board shall have the power at any time to appoint any person to be director to fill casual vacancy. The director so appointed shall hold office in accordance with the term of appointment. For public company, the director so appointed shall hold office in the next AGM. A director may be removed before the expiration of the director's period of office in the following section 206 subsection 1 subsection A subsection B, which is subject to the Constitution. A director may be removed by ordinary resolution for a private company. Notwithstanding anything in the Constitution or any agreement between a public company and a director, a company may, by ordinary resolution at a meeting, remove the director before the expiration of the director's tenure of office. For public company, the director may be removed by passing ordinary resolution at a meeting, and special notice is required for the resolution, according to Section 206 subsection 2 and subsection 3. The special notice also be required for the resolution to appoint another person instead of the director at the same meeting.
Alright, Siti Aisyah has mentioned about a board meeting, special notice, and ordinary resolution. Okay, and I will explain more. A board meeting will be called by giving 7 days notice to all the directors. A special notice will go to the directors informing them about the removal of the director. On the day of the board meeting, a resolution for the holding of an extraordinary general meeting will be passed along with the resolution for the removal of the directors subject to approval of the shareholders. A general meeting will be held by giving 21 days clear notice. In the meeting, the members will be asked to vote on the matter. If the majority is in favor of the decision, the resolution will be passed. For a public company, the framework of Section 206 of the Companies Act 2016 is similar to that of the Companies Act 1965, in which a public company has statutory rights to remove its directors before the expiration of the terms via ordinary resolution. Alright, that's all, and thank you. Okay, the conclusion is, as referred to the above, we know that to be a director in a company must know all the responsible of director duties to make sure the companies have achieved the goal, because a company has to be conducted by a responsible director to make sure the company runs smoothly. Therefore, the company must appoint the director who are qualified to serve as directors. If the director has discharged from bankruptcy, so the board of directors may any time to remove the director. The board shall have the power at any time to appoint any person to be director to fill casual vacancy. All action and decision must be based on laws and rules that has been established so that all decision does not contradict any party. With a positive and efficient method in governing an organization, it will lead to more smooth and more dynamic government. In this case, the individual that is involved must take legal considerations, especially when a foreign party is involved, as there might be a difference in terms of law and rules in governing an organization in each of the country. Okay, that's all. Thank you.